So good afternoon, everyone who is watching. After extensive advocacy, New York State joined a growing group of states that allow medical aid in dying to kind of better understand the effects. The Empire State Bioethics Consortium is developing this recorded walkthrough with the goal of providing a comprehensive analysis of the statutory framework. And I'll let them introduce themselves, but on behalf of ESBC, I want to thank Emily Beer, she's going to be our lead presenter, and David Hoffman and Robert Swidler for taking the time to help us understand this important piece of legislation. So that's my very short introduction. I'll let Emily take it away.
Awesome. Thank you so much. And very happy to do this and glad that ESBC is interested. I'm going to dive right in. I'm sure you're all somewhat familiar with MAID, but to get us on the same page, I like to start with a kind of high-level plain language definition. So MAID is a legal process where it's legal that allows a terminally ill adult patient with decision-making capacity to request prescription medication that they can self-administer for the purpose of hastening their own death. These italicized phrases are doing a lot of work in the sentence, and we'll get into what all of the definitions here are, but I think it's helpful to get on the same page. Um, it's only adults, it's only terminally ill people. You need to have decision-making capacity, and medication has to be self-administered. These requirements are common throughout the country where MAID is legal. There have been several MAID bills pending in New York over the past decade until this most recent one was successful. The Senate and Assembly bills, the original bills, were signed in the spring of 2025. And then we spent the fall watching Governor Hochul closely to see what she intended to do. In December, following negotiations between her office and the bill sponsors, the governor announced that she would sign the act with some additional provisions, which ended up being in another bill that amended the first bill. And then on February 6th, she did sign the act and the amended new bill with those modifications. One of those modifications was a delay in the effective date, so the act will take effect on August 5th of this year. And then one more quick piece of context for you. New York will be the 14th, or sorry, I'm sorry, New York is now the 14th jurisdiction to have legal MAID, so we are not breaking new ground here. Oregon was the first state to implement a MAID law. In 1994, Oregon voters approved Measure 16, a Death with Dignity Act ballot initiative. It was challenged in court, but it did take effect in 1997. And then over the next few decades, we've seen many other states enact MAID laws, both through the legislative process and voter initiatives. The one exception is Montana, where MAID is legal due to a court ruling. And I'm including this slide because it shows that while MAID may feel very new and uncertain to many New Yorkers, we actually have a pretty deep and broad well of experience to draw from. MAID has been happening legally in the US for almost 3 decades. While the laws in each of these states have some differences, like is there a waiting period, and if so, how long, the basic frameworks are very similar. In all of these states, only the patient can request MAID, patients must be terminally ill adults with decision-making capacity, and they must self-administer the medication. With Governor Hochul's additions, New York's act probably has the most stringent requirements, but it's still foundationally very similar to the other laws, so we can learn from the experiences in other states, and we don't need to totally reinvent the wheel in New York. All right, diving into the statute now. So here are the basic eligibility requirements. A patient must be an adult. They must be a resident of New York, and resident is not defined in the statute. They must have a terminal illness or condition. They must have decision-making capacity, and they must be making an informed decision. And then there are other procedural requirements in the law that they need to satisfy. These last 4 bullets are embedded in the definition of qualified individual. The Act tends to use the term patient when the person is going through the MAID process, and then once they meet the requirements, they become a qualified individual, and the doctor can write a prescription. I'm just going to say patient because it's easier, but I wanted to flag that term in case you see it and are wondering where that came from. On this slide, you'll see the statutory definitions of terminal illness or condition and decision-making capacity. You'll note that terminal illness or condition is defined to require that it will produce death within 6 months. This is very critical. There are plenty of terminal illnesses with a prognosis of much longer than 6 months. For example, ALS life expectancy can be several years. I think some people have even lived longer than 10 years. So just having what we commonly call a terminal illness would not be enough to qualify. The death within 6 months requirement must be met. the law is really focusing on people who are facing imminent death because of their illness or condition. And that 6-month prognosis is similar to hospice eligibility requirements. Anyone eligible for MAID is probably also eligible for hospice, and my recommendation would be they should probably enroll if they're interested in pursuing MAID. Decision-making capacity has the common elements of I mean, it's not necessarily how I would write it as a bioethicist, but the elements of this definition are pretty common. It should be familiar to clinicians. Many of them regularly make capacity evaluations, basically understanding and appreciating the healthcare decision, benefits, risks, alternatives, and specifically as it relates to medical aid in dying. Here is a very long definition of informed decision. Included here is the explicit requirement that a decision be made voluntarily of the patient's own volition and without coercion. So wherever we see informed decision written, remember that that's embedded within this definition. The intent behind this long list of things is pretty clear. We want to make sure patients pursuing MAID have all of the relevant information about their condition, their options, their alternatives, and about MAID before being handed any medication. And I'll note some of these slides are long. Feel free to pause if you want to read things, but I'm not going to read the slides out because that will probably be horrible to listen to. All right, an overview of the MAID process. So first, the patient will make an oral request for MAID to the attending physician. They will also make a request in writing, which comes sometime later, and I'll talk about the timing of that when we get to it. After the oral request, the attending physician then conducts an examination of the patient and their medical records. The patient is then examined by a consulting physician, and a mental health professional completes an evaluation. I put those two in the same box because the order doesn't appear to matter under the statute. You'll note that this is a total of 3 separate clinicians who have to evaluate the patient as part of the process. After those 3 evaluations are completed, the attending physician may write the prescription. Then there's a 5-day waiting period before the prescription can be filled by the patient. Only after all of this is complete, the patient can self-administer the medication. So as I said, the process starts with the patient making an oral request for MAID to the attending physician. No one else can make the request, not a surrogate, not a healthcare agent. It can't be done by advance directive. This request must be recorded by audio or video device, and the recording must be permanently stored in the patient's medical record. The Act does not provide any sample language for what this request should look like. If the patient isn't physically capable of making an oral request, they can use an alternative method. At some point, the patient must also make a written request, and there's a form provided in 2899K. An interpreter's declaration is also provided. But if you look at subsection A here in the first bullet, you'll see that the written request can be made when the patient has been determined by the attending physician to have a terminal illness or condition, and this has been medically confirmed by the consulting physician. This would seem to mean that the written request should come after the attending and consulting physician appointments. But the form provided, and there's a screenshot of that on the right part of the slide, uses similar language, but it also wants the patient to assert that the mental health professional has confirmed their terminal illness or condition. You'll see later that's not a requirement listed in the Act itself. So I think there's a little inconsistency here. The mental health language was added to the form as part of the amendments, and it wasn't added in subsection A as well. So there's a little inconsistency that we'll have to deal with. In any event, the patient must sign and date the written request. It must be witnessed by 2 adults who attest that to the best of their knowledge and belief, the patient has decision-making capacity, is acting voluntarily, is making the request for medication of the patient's own volition, and is not being coerced to sign the request. There are restrictions on who can serve as a witness, so they can't be a relative, an heir, or someone who would otherwise benefit financially. They can't be an owner, operator, or employee of the healthcare facility where the patient's living, no domestic partners, no agents, no healthcare proxies, no power of attorneys, and the clinicians who are part of the MAID process also can't be witnesses. And there are similar restrictions on who can serve as an interpreter. After the patient's oral requests kick in, after the patient's oral request, the attending physician's responsibilities kick in, and there are a lot of them. So the attending physician is defined in the law as the physician who has the primary responsibility for the care of the patient and treatment of the patient's terminal illness or condition. There are no requirements here about hospital credentials or other requirements. We're looking at a treating physician. Of course, they have to examine the patient and their medical records. The patient exam must be conducted in person, unless the physician determines within reasonable medical judgment that the requirement would result in extraordinary hardship to the patient. And this has its own definition. So, extraordinary hardship means circumstances in which an in-person examination would cause the patient undue pain or suffering, or would necessitate extraordinary expense or logistical burden for medically necessary transportation. And if this is present, then you can do this exam over telehealth. They have to make a determination of whether the patient meets the eligibility requirements, which you've heard me say before, terminal illness or condition, decision-making capacity, informed decision. And they have to inform the patient about the consulting physician and mental health professional requirement, and then refer out on the patient's request. They also need to provide information and counseling under New York Public Health Law 2997C, which is palliative care patient information. And that statute has this long list of information that is included in patient information about palliative care. So counseling about palliative care and other end-of-life options, including the range of options that are appropriate to the patient, their prognosis, risks and benefits, the patient's legal rights to comprehensive pain management and symptom management at the end of life, information regarding other treatment options, counseling, the importance of completing a healthcare proxy and appointing a healthcare agent, all those types of things. It's a long list. Um, and the attending physician also has to ensure that the patient is making an informed decision by discussing a variety of topics with them. Many of those topics are the same ones I just said from the palliative care and patient information statute. And then the rest of the items are all in the definition of informed decision that we looked at earlier. So it's another long list, but all familiar and, rational things that we would expect to be in this type of counseling. Some more attending physician responsibilities. So they have to offer to refer the patient for other appropriate treatment options, including but not limited to palliative care and hospice care. They have to provide health literate and culturally appropriate educational material about hospice and palliative care that's been prepared by the health department. And if the health department doesn't actually do this, they don't develop the material by the effective date, that's okay. An otherwise eligible patient can't be denied MAID care because those materials don't exist. They have to discuss some logistical issues with the patient, like the importance of having another person present when they take the medication, and that only the patient may administer the medication, not to take the medication in a public place, the importance of informing the patient's family and of their decision to request MAID medication. The attending physician must also inform the patient that they can rescind the request for medication at any time, and they must affirmatively offer the patient an opportunity to rescind as well. That has its own special section in the law, so that's an important requirement. They, of course, have medical record documentation requirements to fulfill that document each step of the process, and that the attending physician should note that all of the requirements have been met. So the act is really positioning the attending physician as the actor who makes sure that all of the required steps are carried out appropriately before writing the prescription. After the patient has their appointment with the attending physician, they must also see a consulting physician. And the requirements here are comparably very light. Consulting physician means a physician who's qualified by specialty or experience to make a professional diagnosis and prognosis regarding a patient's terminal illness or condition. The consulting physician does another examination of the paper and the relevant medical records. They then confirm in writing to the attending physician and the patient that all of the eligibility requirements are met, and they're listed out here again, but they should be familiar to you at this point. The act does not have an in-person requirement for this exam. Next up is the mental health professional responsibilities. So they can be a psychiatrist or psychologist. The technical definition in the Act references the American Board of Psychiatry and Neurology. So technically a neurologist might qualify here too, but practically speaking, we're probably going to focus on the psychiatrists and psychologists. They have to do their own examination and determine whether the patient has decision-making capacity to make an informed decision. and report back to the attending and consulting physicians. If the patient does not have decision-making capacity, the attending physician cannot prescribe the medication. This determination should not be used as a finding that the patient lacks capacity for any other purpose. As we just saw on the prior slides, both the attending and consulting physicians also are making decision-making capacity determinations. So this is now the third clinician making this type of determination. And there's no in-person requirement for this exam either. Once the attending physician receives the required confirmations from the consulting physician and mental health professional, they may now write the prescription. At the patient's request, they can facilitate the filling of the prescription and delivery of the medication. This might seem a bit odd. I don't know that physicians often sort of facilitate the delivery of medications, but made medications have to be made at compounding pharmacies. Your average CVS or Walgreens is not going to be able to dispense these medications. So finding an appropriate pharmacy and coordinating delivery to the patient is an important practical part of the MAID process. After the prescription is written, there's a 5-day waiting period before it can be filled. There's an exception if the attending physician believes that the patient may die before the waiting period expires. Okay, so now we've had a patient make an oral request, a written request. They've had 3 appointments with 3 different clinicians. They've waited for 5 days, and now they have medication in hand. The law is very clear that MAID medication must be self-administered and it must be ingested. Generally, this is accomplished by mixing the powdered medication with a liquid like apple juice and drinking it. Of course, this means that the patient must be physically able to accomplish this. The medication causes the patient to fall into a deep sleep fairly quickly, so it has to be consumed all at once, quickly. If the patient has trouble holding a cup, it's generally considered okay for someone to help hold it while the patient maybe drinks from a straw, but not everyone at the end of life can manage to drink the required volume of thickened liquid quickly enough. For people who can't drink the liquid, there are a few options. A PEG tube or feeding tube could be used, or rectal catheter could be used. In these cases, the patient must be physically able to push the plunger of a syringe to self-administer the medication. And the other important part about ingestion is that these routes rely on adequate gastrointestinal function. If the patient's GI tract, it needs to be able to absorb the medication for it to be circulated throughout the entire body, and not everyone at the end of life will have adequate GI function for this. So clinicians need to keep an eye out for clinical red flags that might indicate problems here. Some clinical issues might be solvable, but some might not. So I went into that just to show you that these requirements, self-administration and ingestion, look kind of dry when you're looking at the statute. Don't think too much about it, but practically speaking, these requirements will exclude some otherwise eligible patients from participation. So the medicine here is going to come into play, and the practical impact of these 2 requirements is very important in terms of who is actually going to be able to make it through this process. So the Act contains broad protections for people acting reasonably and in good faith. There are certain, again, feel free to pause if you want to read these, but there's certainly enough protection to calm fears about liability that clinicians and others might have. Of course, many clinicians are worried about liability arising from their everyday practices, so that makes them extra apprehensive about MAID. But as you've seen, the law basically provides a step-by-step guide on how to provide MAID care and get immunity. Perhaps my colleagues can weigh in on this, but I can't think of any other medical procedure or treatment that has this type of protection and step-by-step guide. Of course, there's no protection for negligence, recklessness, or intentional misconduct. Any clinician can refuse to participate in the provision of MAID medication to the patient. This is explicitly stated in the Act. They don't have to prove anything. They don't have to state any particular reason. They just get to decline to participate. But if they refuse to participate and the patient transfers care to a new provider, they must transfer the relevant medical records to the new provider. In other states, we've seen some physicians who get wind that their patients are interested in MAID, and they try to stop it from happening by refusing to transfer records. Of course, this is improper. Patients have a right to their own medical records, but doing so is also an explicit requirement in the Act. There's no codified duty to refer in this Act, but perhaps my colleagues could comment on the professional and ethical duty to refer as it exists more generally. Private healthcare facilities can also choose not to participate, including prohibiting their staff from prescribing MAID medication and prohibiting their patients from self-administering it. But there's a few more requirements here than for clinicians. So first, MAID must be contrary to a formally adopted policy of the healthcare facility that is expressly based on sincerely held religious beliefs or moral convictions central to the healthcare facility's operating principles. So the entities we're thinking about here are entities like Catholic hospitals. The law is intended to respect their sincerely held beliefs. But what we should not see is healthcare facilities deciding that they'd rather just not bother with MAID because it seems complicated or maybe they're worried about being sued. That's not an appropriate reason for adopting a policy prohibiting MAID. Facilities adopting a prohibition must also inform their patients of the policy before admission or as soon as reasonably possible thereafter. If they adopt a prohibition and a patient requests MAID, they must promptly transfer the patient to a willing facility. Private healthcare facilities may also choose not to participate. Oh, I'm sorry, repeating myself. Facilities with prohibitions can restrict any employees from participating in MAID and can sanction them for participation as long as they inform them of the ban in writing. None of these provisions shall be construed to restrict a patient at home from accessing MAID care. Prohibitions are intended to only impact patients in a facility. So to this, it means to me that if someone is inpatient hospice in a facility with a ban, the facility can stop them from doing MAID. But if the hospice is supporting somebody at home who's living at home getting hospice care, they should not be prohibiting the patient from participation. So this section of the law explicitly states that MAID shall not be considered suicide, and a MAID request does not make someone suicidal. There are numerous provisions that are intended to prevent a decision about MAID from impacting other contracts or policies. So for instance, a provision in a contract or a will that might impact whether someone uses MAID isn't valid. A provision is invalid if it is conditioned on a person requesting MAID or not requesting MAID. Life insurance benefits also can't be denied for MAID actions. Some more of these, you can't condition life or health insurance rates or sales or procurement on MAID requests. Coverage for an otherwise covered service can't be denied because of a MAID request. And there are even restrictions on how healthcare insurers can communicate with patients about MAID. So for example, they can't send letters to patients that say, we're so sorry, we're denying coverage for this treatment you're requesting. But by the way, did you know we pay for aid in dying? Can't do that. In practice, I'll tell you most private insurers don't cover MAID at all, or maybe limited pieces of the services. Perhaps we'll see that change, but it's not common at this time. And federally funded programs like Medicare can't cover MAID either due to the Assisted Suicide Funding Restriction Act of 1997. So there's a bit of a financial barrier for sure here that patients have to overcome. The appointments, the medications, all of these pieces that we've talked about will likely mean out-of-pocket expenses for a patient. We also have a safe disposal of medication provision so that anyone who ends up with unused MAID medications after the patient dies have to bring it to a qualified facility for disposal. On death certificates, the attending physician may sign the patient's death certificate, and the cause of death listed on the death certificate is the underlying illness or condition. It's not suicide, so we don't need to get a medical examiner involved here. On reporting. So the Act creates an obligation for the Commissioner of Health to review a sample of records maintained under the Act. They also need to adopt regulations to establish reporting requirements for physicians. Any information they collect is not a public record, not available for public inspection, but the Commissioner will need to prepare an annual report with data on utilization and compliance, which will be public. Many of the other states have reporting requirements. Some departments of health issue very long and comprehensive reports. Others are more high level, so we'll have to see what the New York Commissioner of Health decides to do here. On penalties, we have a section on penalties. Nothing in the Act limits professional discipline or civil liability resulting from a violation of the Act, negligent conduct, or intentional misconduct. And violation of the Act can make someone subject to whatever applicable criminal liability exists under state or federal law. And for the sake of completion, the last section in the law is a severability clause. So if any provision is found invalid, it doesn't impact the validity of other provisions. And I put here at the end a summary of the governor's primary amendments. So if you were wondering what the governor did to change the law, the big ones are here. So the mental health exam is now required for every patient. Previously, it was at the discretion of the attending or consulting physician if they had concern about decision-making capacity. Now, every person needs to have the mental health exam, and this is unique to New York. The residency requirement was added. The recording requirement for the oral request was also added. I don't think any other state has a recording requirement. The attending physician exam must now be in person. Before, that was not specified. The 5-day waiting period is also new with the amendment, and the effective date was delayed. But with that, I think I'm going to take a break from talking and turn it over to my colleagues for whatever comments or discussion you have.
Thank you so much, Emily. That was a Herculean effort. Excellent review of the law. And let's clarify that our purpose today is limited to reviewing the law. There are a myriad set of clinical, ethical, and administrative issues that we can talk about later. This is just a very high level review of the two statutes themselves. By way of explanation, there was no effort, principally due to the time schedule, to integrate the original law adopted by the legislature over the summer and what are referred to technically as the chapter amendments that were adopted by the Assembly and the Senate 2 days before the governor actually signed both of the bills. So what Emily just presented is an integration of those two technically separate pieces of litigation. Now, a few clarifications on language, because words don't always mean the same thing in legislative parlance as they do in spoken English or in medical vernacular for that matter. So let's start with the notion of an attending physician. To many of us in healthcare, attending physician is a reference to a medical staff status within a hospital or other healthcare organization. That is no part of the meaning of attending physician under these statutes. You don't have to have any hospital affiliation at all to be an attending physician. So for definitional purposes, we should think of that as being the patient's treating physician, including treating physician just for the purpose of MAID. For example, if a patient has ended treatment with an oncologist. The next thing everyone should be aware of is the definition of residency for purposes of the new residency requirement. The bill does not define residency, and that was on purpose, but everyone ought to be aware that there was some discussion of the residency requirement in the debate, in particular in the state assembly, and that discussion becomes part of what we lawyers refer to as the legislative history of the bill. And Assembly member Amy Paulin made it very clear that residency under the MAID law is no different than any other requirement for something restricted to residents, for example, getting a driver's license. So the proof and the documentation and the time frame of residency can be established in the same way as any other residency requirement. There are no higher standards. Third, the definition of terminal. This is a little lawyer speak and a little technical. We discuss terminality in the context of MAID as a terminal diagnosis with a prognosis of 6 months or less to live. The statute incorporates the 6-month prognosis into the definition of terminal. So if you have a terminal diagnosis for the purpose of this MAID statute, it means that you are diagnosed with, for example, cancer or ALS or Parkinson's disease, and that a doctor has determined your prognosis, your expected duration of life is less than 6 months, which means that you can have a terminal illness with a prognosis of more than 6 months, and that would not be a terminal illness for the purpose of the statute. And finally, just a quick comment on the absence of a duty to make a referral by clinicians or healthcare organizations that are exercising the conscientious objection provision. There's no statutory requirement, but that is inherent in the standard of care for all medical treatment. If a clinician is not willing or able to provide a type of care that a patient needs, it would be considered abandonment if the clinician did not make a referral. So that's again part of the law of tort being incorporated into the scheme set forth in the medical aid in dying law. So those are my couple of quick comments. Jorge, Robert, anything more?
Yeah, I have some comments. Jorge, would you like me
No,
to
no,
go
go
or
ahead, please. Yes.
Okay, sure. Well, first of all, Emily, that was a terrific summary, very clear, and it's going to be very valuable. So thank you for that. And also, David, for your comments, which I agreed with. Um, in my background as general counsel to a hospital system for many years, my first instinct in hearing this was to think about how are staff going to comply with all these very specific requirements. Hospital's going to need forms, preferably electronic forms, to make sure every step is completed before you can move to the next step. It's going to need policies. It's going to need training. It's going to need scripts for clinicians. It's a lot. But this particular program is a summary, and it's for the Empire State Bioethics Consortium. So I wanted to focus on two, what I regard as important bioethical aspects to this a new law. First comment is, I think it's very significant that the law clearly states the request can be made only by the patient and only by a patient with capacity. It specifies that it cannot be made by any other individual, including the qualified individual's healthcare agent or other agent or surrogate or via advance directive. That's not something novel. That's in all the other MAID statutes as well. But I think it's an essential part of the ethical case for the proposal. And I hope we forge a consensus to hold the line there. I've seen in the span of a decade, principally the 1980s to 90s, the evolution of the right to forego life-sustaining treatment from a right of a capable patient to refuse to make that decision, to the right to decide by advance directive, to the right to appoint a healthcare agent, to finally allowing a surrogate decision for incapable patients who didn't make a decision for themselves. And I not only supported, I advocated for every step in that progression. But I see MAID as different in character from decisions to forego life-sustaining treatment. I've been trying to put my finger on what that ethical difference is and why it troubles me to think about the potential for progression to surrogate decision-making or advance directive. And I think it has to do with the imperative to decide. With life-sustaining treatment, a decision has to be made one way or the other for this incapable patient. There's no avoiding it. There's an imperative. There is not the same kind of imperative with medical aid in dying. It can be avoided for surrogate decision-making. And second, I think there is a difference between discontinuing treatment or foregoing treatment and aid in dying. The voluntary decision of a capable patient is what places MAID on the ethically acceptable side of the line, while a surrogate decision to aid a patient's death carries too high a risk of abuse and is a bridge too far. So I hope to persuade the bioethics community to recognize the importance of that provision that's in here. And it's very clear that this has to be made by the capable patient and to hold the line there, because I foresee pressure to relax that line. The second issue, which both Emily and David alluded to, has to do with the facility conscience clause, although I think David was talking more about the physician, the individual physician conscience clause. 2899M allows a private healthcare facility to prohibit prescribing, dispensing, ordering, or self-administering of medication in the facility and an affiliated facility if they adopt a policy based on the sincerely held religious or moral convictions central to the facility's operating principle. So again, as a lawyer and as a former hospital counsel, I'm seeing a lot of interpretive issues that could arise. What's a private healthcare facility? What's an affiliated facility? Private healthcare facility, we've been through before. That phrase is from the Family Healthcare Decisions Act. although I don't think it's been interpreted by courts, but it would be any non-governmental facility, I assume. Um, What's an affiliated facility would include, for instance, a captive PC. There's all kinds of creative relationships between the facility and other entities. So there might be some issues there about who is subject to the facility's prohibition and who isn't. And the clause allows the facility to prohibit certain steps involved in the MAID process. And it's not clear to me, maybe it is to my colleagues, whether that permits opting out of all the steps in the MAID process or only specific ones. It doesn't talk about the determination of capacity or the disclosure of rights and that part of the participation in MAID. And but above all, I think the interesting issue is, and Emily alluded to this, what is for a secular facility, what are its moral convictions that are central to its operating principles? Is that something that the facility can just run back to its board and get its board to adopt a resolution that says that this is central to our operating principles, or does it take more of a historical record? That's going to be an interesting issue going forward. But apart from those interpretive questions, because that's really an interpretive question, I think for bioethicists, the clause is going to raise ethical issues that are familiar from facility conscience clauses and abortion and life-sustaining treatment decisions. If it's ethically acceptable and lawful, but if it's ethically acceptable for a capable patient to elect MAID, is it ethically acceptable for a facility to prohibit the accomplishment of that? And like I've said, we've faced that before with abortion and other withdrawal treatment issues. We're going to face it again here. I tend to think in our diverse society, we need to have some sort of conscience opt-out clause for the facility. I just hope, like Emily said, that facilities in determining their position are looking really at their mission and their conscience and not just their risk manager's advice. So that was my comment.
I just, at least from my perspective, I want to highlight also a couple of, I guess, open issues, and which Emily alluded to throughout the presentation. And yes, Emily, really great summary of the law, so thank you. But thinking about the practical implementation, because we may see think about unintended consequences leading to barriers that I think are almost inconsistent with the intent of the law, right? And the first one I want to characterize as more like care deserts. We have recent amendments mandating the attending physician having the examine the patient in person. And while there is a waiver for kind of extraordinary hardship and the documentation of undue pain, extraordinary expense, I feel like the extraordinary hardship is a very high evidentiary bar. So I'm really curious to see how, if at all, the regulation explains it, right? Because for patients in underserved and rural areas of the state, if they don't have a participating provider within a reasonable radius, right, you are effectively closing access to MAID for them. Right? The other piece, and I think this one was a big topic of conversation when I was back in the Senate, was the financial viability, the ability to pay as a big variable in the rollout of medical aid and dying. And, the statute is basically silent on reimbursement of professional services. But even if we end up with some sort of reimbursement scheme, like Emily was saying, third-party healthcare payers may not adequately cover the multiple consultations that we now have, right? So absent kind of mandated coverage for the professional side of it, there's kind of a risk, again, that the system is going to manifest essentially kind of a tiered access model, which is basically predominantly open to folks that are able to pay for it at the end. That's really the issue. And then just kind of the last thing I wanted to point out is just additional procedural requirements, right? That again, it can create kind of challenges for patients in the terminal phase. You have the waiting period. You might have the imminence exception, but what does that mean, right? And then the logistical burdens of just transferring folks. We even facilities, even though they have to promptly transfer a requesting patient, there are logistical, emotional burdens to the transfer, right? And that can kind of have a profound barrier to access. And then how are we going to hold them accountable for this? And I know, David, you were speaking about tort law, but that also has its own set of access issues, right? So I think it's kind of an open question there, but I just wanted to highlight those three issues going forward. And yes.
I think it's fair to observe that not everything in the bill has a clear reason-based justification, something that everyone who works in legislation, especially public policy legislation, knows, something that Robert and I lived for 17 years around the passage of the Family Healthcare Decisions Act. It's what Otto von Bismarck, the Chancellor of Germany, said. If you like sausage or legislation, it's best not to know how either one is made. And with that, unless there are last comments, thank you, Emily, and thank you, Robert and Jorge. We stand ready to answer any more questions that ESBC has for any of us. Thank you.
Thank you.